Hey folks, Dale Davidson here, the VA guy from Davidson Law Offices, and thank you for tuning in today. So hey, look, we've got a full show for you today, talking about some veterans benefits, and we've gotten a lot of questions here lately about protected versus unprotected ratings. Got a lot of people out there worried that, they're going to be subject to a new C&P exam and that their rating's going to go down. So we're going to talk a little bit about that today. So sometimes the VA re-examines you and determines that your disability has, to a certain degree, improved. And we hope and pray that, your disability has improved because you just don't have the same quality of life prior to the disability. So anyway, sometimes the VA seeks to reduce your disability rating or to, God forbid, terminate your service-connected status entirely. This happened to a client of mine over in southwest Georgia, where he was in Vietnam, and he was a tunnel rat, had prostate cancer. Was successfully treated, went to his doctor for some follow-up visits. The doctor reported that he was in remission. Of course, you never, ever are cured from cancer. You're just in remission. And so the VA says, oh, wow, so you are cured. So they reduced his disability rating from 100% down to 40%. Big tragedy there. But hey, aren't there rules against this? Absolutely. So a reduction in a veteran's disability rating is permitted only where certain circumstances exist and where particular legal guidelines have been satisfied. We're going to talk about those today. So the law imposes legal requirements in the VA before they can reduce your benefits. Moreover, the VA has the burden of establishing by preponderance of the evidence that a reduction is warranted under the relevant regulations. So, what is a regulation? Guess what a regulation is? It's the VA's interpretation of the laws that govern them. Holy cow. Maybe that's the fox in charge of the hen house. Don't know. But hey, there's good news in all of this mess. That if your rating is protected, or your service-connected status is protected, the VA cannot, they're entirely prohibited by statute or regulation from reducing your rating unless you committed some kind of fraud. Never really heard of anybody or come across any fraud, but I guess it can exist. That'd be pretty hard to. You'd have to have a doctor involved in that. But hey, so if you have a protected rating and you didn't commit fraud, your benefits are guaranteed for the rest of your life. That's the good news. If your rating is not protected, the VA must ensure that their requirements, the law and their regulations are met before they can reduce your disability rating. Guess what? If they don't follow the law or their rules, then you get your disability rating back. In the case of my client in southwest Georgia, who was in Vietnam and prostate, he died before we got his benefits reinstated. So they lost. The whole family lost in that one. He was not married. So let's talk about the requirement of sustained improvement to reduce a rating level. Let's say you've been rated for 5 or more years, okay? So let's talk about that. If your rating has stabilized, meaning it has continued for a long period of time, meaning 5 years or more, whether it's 10% or 100%, you're protected. When I say protected, your rating can't be reduced unless all the evidence in the record, the VA record, shows that sustained improvement in the disability. Okay? So the VA cannot use a single examination to reduce your rating. They've got to use your entire record. So all of the evidence of the record, of your record, must support the conclusion that sustained improvement of your disability has been demonstrated. So the requirements for this evaluation of your complete medical history operate to protect you, the veteran, against one lone incomplete or inaccurate report from an examiner that says, hey, Dale's right knee is good to go. He's okay. He is totally cured from that. Well, the problem is if I've been stabilized for 5 years and I was at a 20% on my right knee, they can't reduce it because of that one crazy evaluator's report, okay? Again, because my disability is stabilized, the VA has got to take care when proposing to reduce my rating evaluation or your rating evaluation. There's other rules that the VA's got to follow before reducing your rating that has been in effect for 5 years or more. And hey, again, I keep stressing this, it's the entire record. It's not just one examination, okay? And again, if you have one examination that says, hey, you're totally remediated, you're okay, you're healed, then you're certainly entitled to get opposite or another medical opinion to show no, you're not. Okay, so don't give up hope if that one person from that C&P exam rules adversely against you. Okay, let's talk about if your disability is subject to temporary or occasional improvement. Again, it's not going to be reduced on any one examination. So even though I've shown material improvement in my physical, my right knee, or my mental condition, and that's been clearly demonstrated, the VA will consider whether the evidence makes it reasonably certain that improvement will be maintained under the ordinary conditions of life. So my knee has improved dramatically, and so they are expecting it to continue to improve. Let's talk about protections against reduction after 20 years of continuation rating. If your disability has been continuously rated at or above a particular rating level for 20 years or more, the VA cannot reduce your rating below that level unless you committed some kind of fraud. Again, I think fraud would be hard to pull over on the VA because of the C&P exams, and you'd have to have some kind of collusion in there with the doctors. But anyway, so fraud's the only way that you can, if you're 20 years of continuous rating at a particular level, they can't reduce it without proving some kind of fraud. For example, I'm a veteran and I'm granted compensation based upon an original rating of 30%. And for the next 20 years, 21 years, whatever, the rating varies between 30% and 100%. Okay? The rating cannot be reduced below 30% in the absence of fraud. I know it's fluctuated throughout the years, never went below 30, and it cannot go below 30 under this 20-year rule. Okay? So the 20-year protection rule applies even to rating levels that are assigned retroactively because of a previous final decision received based on a clear and unmistakable error. You know, the Q errors, okay? That is, if a rating is retroactively increased based upon a finding of a clear, unmistakable error, and the effective date of the increase is more than 20 years in the past, then the revised disability percentage is protected by the 20-year rule. A little confusing, I know. Just think of it this way. If you have a Q decision that goes back past 20 years and increases your disability, then you're protected. Okay? So this rule applies even if there's been a change in the nature of your disability. So for example, my left knee instability was service-connected back in 1983 at a 10% rating, okay? Back in 2001, I filed a claim for increased rating, and in January of 2003, the VA said, I'm sorry, but you don't deserve an increase in rating. Now, those dates are important because 2003 minus 1983 is 20 years. We're in the 20-year rule, okay? A later VA examination revealed that I had arthritis in my left knee, and the examiner found that the arthritis in my left knee was causally related to my service-connected disability in my left knee. So the VA reclassified my disability as residuals of the left knee arthritis. And the VA told me that they couldn't assign a separate disability rating because to do so would violate the anti-stacking rule or the pyramid rule or whatever, where you can't stack benefits. So my left knee instability may have been healed or resolved in accordance with the VA language, okay, during my appeal, but my rating is protected because I was continuously rated at 10% for the 20 years. Remember, 2003, 1983 is 20 years, all right? Now, because my rating was, and I developed arthritis because of my service-connected disability, I'm entitled to a separate rating, including reinstatement of the improperly reduced rating. Okay, so I'm entitled to 10% for my knee and 10% for my arthritis. That's because of the 20-year rule. It can really work to your advantage. Now, you might logically think that when the VA considers reducing a 100% rating, that the issue to be decided is whether my current symptomology is equal to the symptomology needed for the 100% evaluation. Not true. Don't think that way. The VA is not logical. But in the absence of a clear error in its previous total disability rating, the issue the VA must decide is whether there has been a material improvement in the physical or mental condition evaluated as 100% disabling. So they're looking at the material improvement versus the symptomology, okay? So don't think symptomology. Let's try to get on the VA's level and think in terms of material improvement. So without an examination that confirms such improvement, the VA is prohibited from reducing your rating. The VA has got to compare the evidence it relied on in its most recent decision to continue your evaluation. If it's 100%, it'd be 100%, with the evidence it intends to rely upon to reduce your rating. Okay? So the VA may look at both medical and non-medical evidence in determining whether your condition has materially improved. Now, what would be some non-medical evidence? Do you work? Do you physically exert yourself, mowing the grass, doing whatever? Okay? They get the chance to look at things like that to determine if, in fact, your condition has materially improved. Be careful as to what you're doing out there. If you're not supposed to be doing it, but you're doing it just because, hire somebody to mow your grass. Hire somebody to do the physical work for you, okay? You don't need to jeopardize your rating for a little bitty paycheck. Look, in some instances, the evidence reveals some improvement in your service-connected disability. Hopefully, Okay? If this is the case, then we need to compare the most recent evidence with the earlier evidence to be used to continue or establish your disability evaluation. Hopefully it's 100%. If feasible, you need to argue, or we would argue for you, that there has been no improvement. Alternatively, we or you, somebody needs to argue on your behalf that even though there has been some improvement in your service-connected disability, that it's not significant enough to constitute a material improvement. Buzzwords. It's not a material improvement. We're not worried about symptomology, we're worried about material improvement. I touched on physical work and things of that nature, but let's just ask the question, what happens if you're employed or actively seeking employment? How does that affect you? Would that constitute a material improvement in your disability? I mean, because if you're disabled and you cannot work, how can you work if you haven't gotten some kind of improvement? Okay? So the regulations preclude, they disallow a reduction unless the improvement was attained under ordinary conditions of life while working or actively seeking work. So a private medical opinion stating that you have not medically improved since your 100% evaluation was assigned or continued is very important, can be crucial. So get one. Don't argue that your service-connected conditions still meets the definition of 100% rating. We're trying to argue that there hasn't been a material improvement. Okay, that's the test. The rating schedule is not the issue. The issue is whether your service-connected condition has material improved. And you can refer to your rating schedule, but don't rely on it. Okay, and always look to get a competent medical opinion saying that your disability has not had any material improvement. Even if the VA is justified in reducing your total rating after applying this analysis, okay, you can still preserve your rating under the rules. If the VA determines that a reduction in your total rating, let's say it's 100%, let's say that we're going to reduce that 100%. But the record reflects that you're unable to engage in substantial gainful employment by virtue of your service-connected disability. You must be awarded 100% rating based on TDIU, total disability unemployment. Okay? Hey, it gets better because once you receive benefits at the total rating level based on TDIU, the VA cannot reduce the benefits unless there's clear and convincing evidence establishing that you are capable of actual employment. Let's shift gears a little bit. And now we're going to talk a little bit about rating reduction in unprotected cases, cases where you don't have either total disability or your total disability rating has not been in effect for 5 years or more. What happens in those cases? So where your rating has been in effect for 5 years or more, you may still want to argue that the VA regulations and substantive rules protect your disability rating from being reduced. For example, any proposed reduction must be based upon a review of the VA of the entire history of your disability. Now, again, this is where competent medical evidence on your part becomes crucial. You can submit competent medical evidence saying that you should not be reduced because of, here's my evidence saying that there's been no material improvement in my disability. So the VA must also determine whether there's been an actual change in your disability. And any improvement must reflect an improvement in your ability to function under the ordinary conditions of life. life and work. Okay, and examination reports reflecting any such change have got to be based on a thorough examination. So just like the 20-year rule, this 5-year rule says, well, look, we're looking at the entire record, but they throw in some more terms for us to kind of marinate on, and that talks about the ordinary conditions of life and work. In addition to the medical opinion, your medical opinion might say, Dale has not improved, or his disability has not improved under the ordinary conditions of life and work. And let's use their language, to show that, hey, my doctor is saying that my condition hasn't improved under the ordinary conditions of life and work. Maybe you get a doctor, maybe you get some kind of other individual, a career specialist, who writes you up some kind of report that says, look, Dale can't work because of his disability, okay? Which would be more evidence to show that my disability hasn't improved under the ordinary conditions of life and work because I can't work. Look, the VA regulations impose a duty on themselves, okay, on the VA, to make an explicit finding that by a preponderance of the evidence that there's been improvement in your disability rating. Specifically, it's essential both in the examination and in the evaluation of the disability that each of your disabilities or disability be viewed in relation to your entire history. Okay, let's look at your entire file. It's responsibility of the VA to interpret reports of examinations considering your record. So let's make it easy for them. Let's put in the record medical opinions saying that his disability has not improved such that he can't function under the ordinary conditions of life and work. Let the VA marinate on that a little bit. Once the VA gets the file and reconciles everything, and then they'll have a clearer picture of what should my rating be, what should your rating be. The law and the VA rules impose requirements on VA reductions. So again, looking at the entire file, your entire history, okay, when any change in an evaluation is to be made, the VA needs to make sure that there has been an actual change in your condition, for better or worse, and not just because one examiner thinks a different way than the other examiner. They're looking at the entire thing. But again, you get the chance to submit your own competent evidence saying that there hasn't been a change. Okay? There hasn't been a change. So it's quite obvious to me, okay, that in rating reduction cases, the VA is required to ascertain, okay, determine, based upon a review of the entire record, whether there's evidence exists to reduce your disability. It's also clear to me that a lot of times when my clients come in and I see that they've been reduced, that they have been reduced because of an error of the VA not taking into account the entire record. Or in the case of my client who died of prostate cancer, saying that remission is cure, so therefore reducing his disability. We're all humans and mistakes are made. So we're here to help you because we want to make sure that the VA is reviewing the entire evidence of your record and determining and making an explicit finding as to whether the evidence is good enough, strong enough to reduce your disability rating. Hey, from the Dear VA Guy, we appreciate you. Thank you for watching us. It really means a lot to us. The views are up, the subscriptions are up. We do appreciate that. So I've got this video here. It's called VA Medical Exams for Disability. Don't lose your rating. You need to go check that out. It's very informative too. Hey, until next time, you be blessed.